All right, future doctors, preparing for the MSRA SJT can feel a bit like, well, navigating a maze, right?
Absolutely.
So here on the deep dive, we're trying to build you a clearer path. We're cutting through the noise, helping you truly think like a doctor in those tricky situations.
Yeah, exactly.
Prioritizing safety, acting with integrity, understanding the legal stuff, proportionality, knowing when to escalate early, and yeah, documenting absolutely everything meticulously.
That's the plan.
Our mission today is to give you those essential nuggets, those aha moments that really, really stick.
Precisely. Today, we're doing a rapid-fire deep dive into the General Medical Council's core guidance. We'll touch on key UK laws, too, like the Data Protection Act 2018 and the Equality Act 2010.
Okay.
We've got, I think, 33 crucial areas on our radar, all distilled from the latest UK summaries.
Oh, okay.
Think of it as your supercharged cheat sheet, really,
Yeah.
for the exam. Packed with insights you can immediately use, ready to dive in.
Absolutely. Let's start right at the foundation. Good medical practice. What does it actually mean to be a doctor here in the UK? 1. Good medical practice duties of a doctor.
Okay, so good medical practice essentially defines what being a good doctor in the UK is all about. It covers professional values, behaviors, all geared towards patient-centered care, professionalism, and importantly, public trust.
Right.
The absolute core idea is always putting patient care first. You've got to stay competent, keep your skills up to date, and be ready to justify your decisions and actions.
Okay, so let's paint a picture. Imagine you're that new foundation doctor, first night shift, maybe feeling a bit out of your depth, and a complex patient suddenly deteriorates quite rapidly. What's the immediate priority there?
Get senior support.
Immediately.
You absolutely cannot delay escalating because you're worried about looking incompetent or inexperienced.
Yeah, that's a big pitfall.
It really is. Remember, patient safety trumps everything. In the exam, you'll definitely find questions testing this: acting within your competence, communicating clearly, working with a team, being honest, and documenting meticulously.
That documentation point again.
Always.
Yeah.
Because if it's not written down,
Yeah.
well, it's like it didn't happen in many ways.
Okay, so maybe a way to remember this is care, competence, action, especially on safety, relationships with patients and colleagues, and ethics, like honesty and integrity. It's all about maintaining that trust and knowing your limits.
That's a great way to put it. Care works well.
Handling patient information.
Okay, building on that foundation of trust then. How we handle patient information is absolutely fundamental, isn't it? What's the real essence of confidentiality in medicine?
It's your ethical and legal duty to protect patient information. It's a balancing act, balancing privacy with sharing what's absolutely necessary for safe and effective care. The key rules: use the minimum necessary personal information. Always manage and protect information properly. Stop improper disclosure. And you need to know the difference between implied consent, which often covers direct care, and when you need explicit consent for disclosures that go beyond that immediate care.
Okay, scenario time. You're on a really busy ward, things are hectic. A colleague, maybe distracted, leaves a patient's printed notes just lying on the desk while they nip away. What's your immediate move? What's the safest thing to do?
Right, you need to act instantly. Secure those notes, cover them up, move them somewhere safe. Then have a quiet word with your colleague later, discreetly, just reminding them about information security.
So ignoring it is not an option.
Definitely not. That risks a serious breach of confidentiality and data protection rules. For the exam, think protect. Protect information, keep it relevant, use only what's necessary, maintain trust, get explicit consent when needed, comply with the law, and tell the patient about disclosures where practical.
Education and training disclosures.
And sticking with confidentiality, but moving into education. Patient information is obviously vital for learning, but again, it needs really careful handling. The gold standard for training purposes is always anonymized information.
Okay, but what if you're, say, using patient images in a teaching presentation? Even if you've anonymized them, is there something else you should really be doing? A step that's maybe easily missed?
Yeah, absolutely. You need explicit patient consent for sharing any identifiable data for education or training, unless there's a clear legal basis. And honestly, even for properly anonymized images or case details, especially if it's a rare or sensitive case, getting consent is still best practice. It shows respect.
Right. Makes sense.
Common pitfalls here include thinking you've anonymized something when you haven't quite managed it. Maybe combining bits of information could still identify someone. Or just assuming you have consent for educational use when it's outside direct care.
So for the exam checklist on this one, Maybe ACCESS.
I like that. ACCESS, anonymize first. Consent explicit if identifiable. Case study care, handle with care. Educate students appropriately. Secure the data. And be extra sensitive with potentially identifiable material.
Employment insurance disclosures.
Okay, switching tack slightly.
Right.
What about when third parties come knocking? Employers, insurance companies asking for patient data. What's the core principle guiding us there?
It really boils down to two things: informed consent and relevance. You absolutely must have seen written consent from the patient before disclosing anything.
Okay.
And you need to be satisfied that the patient actually understands why their information is being shared, the scope of it, and potential consequences. Then, critically, only disclose factual, substantiated information that is directly relevant to the specific request.
So no sending the entire medical record just because they asked?
Definitely not, unless it's specifically required and justified, perhaps for some benefit claims or legal processes. Generally, avoid it. It's usually excessive.
What about this scenario? An insurance company sends you a form, the patient has consented, but the form asks for their entire medical history, including totally unrelated past stuff. What's the safest next step?
Right. You provide only the factual information that's relevant to that specific insurance request. Make sure it's unbiased and you can back it up. And then you politely inform the insurance company that providing the full record isn't usually appropriate and might breach data protection principle. Stick to that minimum necessary idea.
Got it. And for a quick checklist here, maybe REPORT?
Let's see. REPORT. Ensure it's relevant. Get explicit consent. Offer the patient a review of the report before sending. Stick to only facts, no reasonable delay, act promptly, and make sure the third party is aware of the scope. Yeah, that works.
Serious communicable diseases.
Okay, now this one can feel really challenging. Balancing patient confidentiality with public interest, especially around serious communicable diseases, think HIV, TB. Confidentiality is still vital, but it's not absolute here.
Right. It's a classic ethical dilemma. So take the example of a patient with a serious, highly transmissible disease who knows the risks but refuses point blank to tell their housemates who are clearly at risk. What's the doctor's duty then?
Well, first, you really try hard to persuade the patient to disclose the information themselves, explain the risks, offer support. But if they continue to refuse and you genuinely believe that not disclosing poses a risk of death or serious harm to others,
Then what?
then disclosure in the public interest may be justified, even without consent.
Yeah.
But this is a really significant decision.
Yeah, it sounds like it.
It is. So you absolutely must seek advice first. Talk to your Caldicott guardian, that senior person responsible for patient data, or an experienced senior colleague. Document everything meticulously.
Okay. A mnemonic for this tricky one. CONTACT.
Let's try it. CONTACT. Seek consent first. Consider others at risk. Is it notifiable? Maintain trust where possible. Anonymize if that serves the purpose. Assess capacity. And talk to the patient, explore options. Yeah, that covers the key steps.
Fitness to drive. DVLA, DVA.
Okay, another area where public safety bumps up against confidentiality. Assessing patients' fitness to drive. What's the doctor's role here in the UK system with the DVLA or DVA in Northern Ireland?
Your main job initially is to advise the patient. It's their legal responsibility to inform the DVLA or DVA about any medical condition that might affect their safe driving. You need to alert them to this duty.
Right.
Now, if a patient is clearly unfit to drive, perhaps due to a condition like poorly controlled epilepsy or worsening dementia, and they insist on continuing to drive despite your advice, and you believe they pose a real risk of causing death or serious harm to others,
Then you step in.
then you may need to breach confidentiality and inform the DVLA or DVA directly, even without the patient's consent. But crucially, you should always try to tell the patient beforehand that you intend to do this.
So what if they just refuse? You've advised them clearly, they know the risks, but they say, nope, I'm still driving to work.
You make every reasonable effort to persuade them first. Maybe offer a second opinion if they dispute your assessment. But if they still refuse, and the risk is serious, you must prioritize public safety. You contact the DVLA, and you inform the patient, ideally in writing, that you have done so.
Okay, this feels like prime SJT territory. A mnemonic.
Prive.
Drive. Check DVLA guidance. Assess risk of serious harm. Inform the patient of your intentions. Verify the diagnosis and fitness standard. Make every effort to persuade first. Good one.
Gunshot and knife wounds, police.
Moving on to another really sensitive area where confidentiality meets public interest, reporting gunshot and knife wounds. The general rule is if it seems to be a non-self-inflicted gunshot wound or a knife wound resulting from an attack, the police should usually be informed.
Okay. But what if it's less clear-cut? Say a 16-year-old comes in with a nasty knife wound, claims it was an accident shopping veg, but you have a nagging feeling it might be gang-related.
Right. First things first. Treat the patient. Their immediate medical needs are the absolute priority and must not be delayed by police involvement or questioning. Always.
Then, because they're a minor, under 18, you immediately think safeguarding. This is a potential child protection concern. So you'd consult with a senior colleague or, ideally, the hospital's safeguarding lead. They help assess the risk to the child or others. Based on that assessment, you decide whether to notify the police or social services following local procedures.
And document everything carefully.
Meticulously. The rationale for your decisions is key.
Okay, so a mnemonic for this. STAB.
STAB, safety first, patient care. Tell police if it's an attack, non-accidental, non-self-inflicted. Ask for consent to speak to police if the patient is able and it's appropriate, and balance confidentiality against the risk of harm.
Responding to criticism in media.
Okay, this happens more often now with social media. What if you or your practice face public criticism, perhaps online or in the local paper? It's natural to want to defend yourself, but patient confidentiality remains absolute.
Right. You can't just jump online and share patient details to prove your point, even if the criticism feels unfair or inaccurate.
Absolutely not. You cannot disclose any patient information in the public domain without their explicit consent. That's a fundamental breach of trust.
So let's take a scenario. A patient's relative posts a really critical, maybe even factually wrong account of the care their loved one received online. They even include details that could identify the patient. What's the safest way for the doctor or practice to respond?
The very first step should be to seek advice. Talk to your medical defense organization or your employer's communications team.
Okay.
Your public response, if any, should generally be very limited. You can explain your duty of confidentiality, that you can't discuss individual cases publicly. You might be able to provide some general information about your usual practice or standards of care, but absolutely no specifics about the patient or their treatment without consent.
Right. Stay general, explain the confidentiality rule.
Exactly. Getting drawn into a public argument with patient specifics is a major pitfall.
So, SILENT for the mnemonic.
Let's try it. Seek advice first. Inform generally, if needed. Limit your public response. Need explicit consent for details. No identifiable information ever. Protect trust. Yes, SILENT works. 9. Personal beliefs and medical practice. This guidance is absolutely fundamental to fair and ethical practice. It stresses that your personal beliefs, religious, moral, whatever, must never lead to unfair treatment, discrimination, or cause distress to patients.
So you have to treat everyone equally, regardless of their lifestyle, background, or beliefs.
Precisely. Treat all patients fairly and respectfully. Your personal views cannot compromise the care you provide.
What about conscientious objection? Say a doctor has a strong personal belief against providing a certain procedure, like contraception or maybe male circumcision for religious reasons. Can they just refuse?
They can refuse to provide a specific procedure due to conscientious objection, and this is crucial only if the patient's care is not compromised as a result.
Okay, so what does not compromise mean in practice?
It means you have a duty to tell the patient sensitively that you object, explain they have the right to see another doctor who can provide the service, and you must actively help them access that alternative care promptly and without judgment. You can't just say no and leave them stranded.
And in an emergency?
In an emergency, you must not refuse necessary, potentially life-saving treatment because of your personal beliefs. The patient's immediate well-being comes first.
Okay. A way to remember this. BELIEF.
DELIEF. Balance your beliefs with professional duties. Ensure equality and non-discrimination. Life-saving treatment cannot be refused on grounds of belief. Inform the patient if you object. Explore patient beliefs respectfully if relevant. Facilitate alternative care smoothly. 10. Financial and commercial arrangements. Conflicts of interest. Right. This is all about maintaining trust by being completely honest and transparent in any financial or commercial dealings related to your practice.
The key principle is that your clinical decisions shouldn't be swayed by personal gain.
Exactly. Your decisions about prescribing, treating, referring patients, or commissioning services must never be influenced by any financial or commercial interest you might have. If there's a potential conflict, you need to declare it formally and potentially exclude yourself from the decision-making process.
Okay, let's take a practical example. You're a GP, and you happen to have a financial interest. Maybe you own some shares in a new private physiotherapy clinic that's just opened locally. A patient comes in with back pain, asking for a physio referral. What's your obligation?
Transparency is key. You must tell the patient about your financial interest in that specific clinic, but then, critically, you must also give them comprehensive, balanced information about all the suitable physiotherapy options in the area, including NHS services and other private providers.
So they can make a truly informed choice.
Precisely. Their decision must be based purely on their needs and preferences, completely free from any influence related to your financial interest. You also shouldn't solicit gifts, and only accept unsolicited ones if they're modest and don't affect your judgment. Be upfront about any fees you charge.
Okay, so a mnemonic for this might be HONEST.
HONEST, honest financial dealings, open declaration of interests, no influence on patient care, exclude yourself from decisions if conflicted, solicit no gifts or money, tell patients clearly about any fees. Yeah, that works well. 11. Doctors' use of social media.
Moving into the digital world now, how does GMC guidance apply to doctors using social media? Does professionalism stop when you log off from work?
Absolutely not. The guidance is crystal clear. The same standards of professional conduct apply online as they do in face-to-face interactions.
So that means confidentiality still applies.
Definitely. Maintain confidentiality, protect patient privacy, and crucially, maintain professional boundaries online. Avoid blurring the lines between your social and professional life. Remember, even with tight privacy settings, nothing online is ever truly private, and it can be very difficult to remove content once it's out there.
What about the classic scenario? A current patient sends you a friend request on your personal Facebook profile, the one with your holiday snaps and family pictures.
Safest bet. Decline the request politely. If that patient then tries to contact you about their medical care through your private profile, you need to gently redirect them back to the proper professional channels, like booking an appointment or contacting the surgery. Don't get drawn into clinical discussions on personal platforms.
Right, keep those boundaries clear.
Exactly. And if you do identify yourself as a doctor online, perhaps on Twitter or a professional forum, use your real name. Be aware that your posts might be seen as representing the profession. Be respectful to colleagues online, no bullying or unsubstantiated comments, and declare any conflicts of interest if you're posting material.
Okay, so maybe SOCIAL for the mnemonic?
Let's see. SOCIL. Apply the same standards online. Keep content only professional regarding patients. Uphold confidentiality. Identify yourself properly if speaking as a doctor. Avoid mixing personal and professional relationships. Limit personal information shared where patients might see it. Yeah, that fits. 12. Ending your professional relationship with a patient. This is a really significant step and shouldn't be taken lightly. Ending a professional relationship with a patient should only happen when there's been a genuine breakdown of trust that fundamentally prevents you from providing good clinical care.
So it's not just because a patient complains a lot or maybe they miss appointments?
No. Complaints or resource issues alone are generally not sufficient grounds. We're talking about situations like violence or threats towards staff, theft, persistent, seriously inconsiderate behavior, or maybe inappropriate advances from the patient, things that make a safe and effective therapeutic relationship impossible.
Okay, so let's say a patient has made repeated, unwarranted complaints against you and the team. It's disrupting care, you've tried addressing their concerns, but the relationship feels totally broken, impacting your ability to treat them effectively. Can you just remove them from the list?
Not straight away. There's a process. First, you should usually warn the patient about their behavior and its consequences. You should try to restore the relationship if possible, maybe explore mediation or alternatives. You absolutely must consult with colleagues or your employer practice manager.
And if all that fails?
If, after all that, the trust breakdown genuinely prevents good care, then yes, you can proceed. But you must inform the patient clearly, in writing, explaining the decision and the reasons, and critically, you must make arrangements for their prompt continuing care elsewhere. You can't just abandon them. Transfer records needs to be smooth.
Right, ensuring continuity of care is vital.
Absolutely. And the decision must be fair, unbiased, and non-discriminatory. Be prepared to justify it.
Okay, and mnemonic.
Yeah.
Maybe CONTINUE.
CONTINUE. Consider if trust breakdown truly prevents good care. Have options been explored? Notify the patient in writing. Arrange transfer of care. Attempt informal resolution first. Ensure decision is non-discriminatory. Help patient understand the reasons. Explain and be ready to justify. Good. 13. Intimate examinations and chaperones. Okay. intimate examinations. These obviously require particular sensitivity, always respecting the patient's privacy and dignity. The core principles from good medical practice apply strongly here.
You mentioned this isn't explicitly detailed in every summary we have.
That's right. Specific detailed guidance on chaperones wasn't in the core summaries provided for this deep dive, so always check your local trust or practice policy for the exact procedures. However, the fundamental GMC principles are clear. Treat patients with respect, protect their dignity and privacy, and always obtain valid consent before any examination.
So, based on those principles, what's the best immediate action if you're, say, a male doctor about to perform an intimate examination on a female patient and you realize you haven't actually offered her a chaperone?
The safest and most appropriate thing to do is to pause. Stop before you proceed with the examination and explicitly offer the patient a chaperone. Explain who the chaperone would be and what their role is.
So offering is better than just asking if they're comfortable with that one?
Yes, offering proactively presents the option properly and respects their right to have one. It ensures their comfort and dignity are prioritized, and it also protects both the patient and the doctor. Documenting the offer and whether it was accepted or declined is also good practice.
Right. And even for non-intimate exams, the basics still apply, don't they? Explain what you're doing, get consent, ensure privacy.
Absolutely. Close the curtains, provide a gown if needed, explain, get consent, ask if they have questions. It's all part of respectful patient care. 14. Maintaining professional boundaries. This is all about the trust inherent in the doctor-patient relationship. GMC guidance is very clear. Doctors must not abuse this trust. You must not view patients as potential sexual or romantic partners.
So pursuing any kind of sexual or improper emotional relationship with a current patient is completely out of bounds.
Totally inappropriate. If a patient tries to pursue such a relationship with you, you need to be firm but professional, reinforce the boundaries, and document it. If this leads to a breakdown of trust where you can no longer treat them effectively, you'd follow the guidance on ending the relationship, ensuring continuity of care.
What about former patients? Is that always okay?
Not necessarily. The guidance says personal relationships with former patients may also be inappropriate. It depends on several factors.
Like what?
Like how long ago the professional relationship ended, the nature of that relationship, and particularly the patient's vulnerability. For instance, pursuing a relationship with a former patient you treated for significant psychiatric issues or a pediatric patient who's now an adult could easily be seen as an abuse of your former position. There's no set time limit, but the more recent or vulnerable, the less appropriate it is.
Okay, scenario. A former patient, someone you treated for depression ending 6 months ago, sends you a message on a dating app. Maybe you found them attractive when they were your patient. What's the safest move?
Decline the message. Given the context, the recent professional relationship, the patient's vulnerability due to depression engaging would be highly inappropriate and risky. It could breach ethical boundaries. If you're ever unsure in these situations, seek confidential advice from your medical defense organization.
Okay. A mnemonic for boundaries. B-O-U-N-D-R-Y.
Let's see. B-O-U-N-D-R-Y. Don't believe you can abuse trust. Sexual emotional relationships are out of bounds. Unsuitable with former patients if recent, vulnerable. Not for personal gain. End gain care to start relationship. Discuss with colleagues' defense body if unsure. Always maintain professionalism. Refer or end relationship if trust breaks due to patient pursuit. And yes, for clarity and communication. Yeah, that covers it. 15. Sexual behavior and duty to report colleagues. Okay, this follows on logically. Patient safety is absolutely paramount here. Doctors must ensure no sexual advances behavior or inappropriate comments are directed towards patients.
And what's your absolute duty if a patient does report that a colleague has breached sexual boundaries, or if you suspect it yourself?
You must act promptly. Report your concerns immediately to someone or an organization that can properly investigate. This could be your employer, your clinical director, HR, the responsible officer, or even the GMC directly if necessary.
No hesitation.
No hesitation. Especially if the suspicion involves potential criminal activity, like sexual assault, in which case you should also report it to the police. Your primary focus must be supporting the affected patient and ensuring their safety.
Okay, scenario. A patient tearfully confides in you that a senior colleague made a sexually suggestive comment during their last appointment. You're shocked. What's the single safest, best next step?
First, support the patient. Listen, reassure them, ensure they feel safe. Then, clearly and accurately document exactly what they've told you. After that, you promptly report the concerns to an appropriate person in authority who can initiate an investigation like the clinical director or the trust's HR department. If it sounds like it could be a criminal offense, you should also involve the police.
So, confronting the colleague directly isn't the right move.
Generally not for serious allegations like this. It could put you at risk, escalate the situation, and it bypasses the formal, impartial investigation process needed. Ignoring it or waiting to see if it happens again is absolutely unacceptable. It puts other patients at risk.
Okay. SAFETY for the mnemonic.
SAFETY. Support the patient first. Take action, report promptly. Put patient for hour. First, their safety is paramount. Escalate to an appropriate investigator. Protect trust in the profession. And, yes, involve police if potentially criminal. 16. Protecting children and young people. This is a huge area of responsibility for all doctors. We have a fundamental duty to protect the health and well-being of children and young people, that's anyone under 18, from abuse and neglect.
And the guiding principle is always the child's best interests.
Always.
Yeah.
That comes above everything else. You need to be able to recognize the signs of potential abuse or neglect, assess capacity appropriately for their age and maturity, and know when confidentiality needs to be breached to protect a child.
Right, that confidentiality point is key, isn't it? Sometimes you have to share information.
Absolutely. While you aim to maintain confidentiality to encourage young people to seek help, if you have concerns about abuse or neglect, or if a child's safety is seriously compromised, you must share that information with relevant agencies like social services or the police, often without parental consent, and sometimes even without informing the parents if doing so could increase the risk to the child.
Okay, scenario. A 7-year-old child comes in with multiple bruises, all at different stages of healing. The parents give vague, inconsistent explanations for the injuries. What's the safest approach?
First, ensure the child's immediate medical needs are met and they are safe right now. Then, given the concerning pattern and inconsistent story, you absolutely must raise your concerns. Talk to a senior colleague, the pediatric team, or your designated safeguarding lead immediately. Follow your local child protection procedures precisely and document every observation, conversation, and concern meticulously.
So you don't just accept the explanation.
No, not when the signs are suspicious like that. You have a duty to investigate further through the proper channels. Confronting the parents directly is usually unwise and could put the child at greater risk. Sending them home without action is unacceptable.
Okay, safeguarding mnemonic. SAFEGUARD.
Let's see. SAFEGUARD, child safety first. Act on your concerns. Find advice, senior safeguarding lead. Escalate following policy. Get consent where appropriate, but welfare overrides. Remember, they're under 18 and potentially vulnerable. Collaborate with agencies. Record everything. And don't discriminate. Yes, that's a good one. 17, 0-18 years guidance. This guidance builds on safeguarding, really. It helps doctors make ethical and lawful decisions specifically for children and young people up to 18. It covers best interests involving families appropriately, consent, and confidentiality in pediatric care.
You mentioned Gillick competence earlier. Can you remind us what that is?
Sure. Gillick competence refers to the assessment used for children under 16 in the UK to decide if they have sufficient maturity and understanding to make a decision about their own medical treatment without needing parental consent.
Okay. So let's take the example of a 15-year-old girl asking for contraception. She understands the implications, the risks, the benefits, but she explicitly doesn't want her parents involved. If you assess her as Gillick competent, what do you do?
If she's Gillick competent and you judge the treatment to be in her best interests, you can provide the contraception confidentially without informing her parents. This respects her autonomy and ensures access to necessary health care.
What about refusal of treatment? Say a 14-year-old who seems competent is refusing treatment for a serious but treatable condition. The parents are maybe unsure now because she's distressed.
That's complex. First, you need a really robust assessment of her capacity. Gillick competence. Ensure she truly understands everything. Talk extensively with her and her parents. Explore why she's refusing. If she is competent and persists in refusing, but the treatment is essential to save her life or prevent serious, irreversible deterioration, and the parents won't consent to override her refusal, you would likely need to seek legal advice about applying to the court for authorization to treat in her best interests.
So it's a high bar for overriding a competent refusal.
It is. But the child's best interests, especially regarding life and serious harm, are paramount. In emergencies, though, you provide immediately necessary treatment without consent if needed.
Okay. CHILD for the mnemonic.
CHILD, assess capacity, Gillick. Prioritize health and best interests. Involve family appropriately. Understand legal exceptions, confidentiality, court. Document decisions fully. 18. Prescribing and managing medicines devices. Right. prescribing. As doctors, you are professionally and legally responsible for every prescription you issue. The absolute rule is you must only prescribe if you have adequate knowledge of the patient's health.
And the prescription needs to be appropriate for them.
Yes, you need to be satisfied it actually serves the patient's needs, is safe, and ideally based on the best available evidence, like NICE guidance or local formularies. You should also be familiar with the BNF, especially the BNFC for children.
What about prescribing for yourself or family and friends?
Avoid it. GMC guidance strongly advises against prescribing for yourself or anyone you have a close personal relationship with, especially controlled drugs or anything potentially addictive or harmful. There might be very rare exceptions in a true emergency where no other doctor is available, but generally just don't do it.
Okay, scenario. A patient contacts you, maybe they've just moved to the area. They ask for a repeat prescription for a controlled drug, say a strong painkiller, that they used to get from their old doctor in another city. You have absolutely no medical records for them. What's the safe approach?
You have to decline to prescribe that controlled drug right then. You simply don't have adequate knowledge of their health or history. It would be unsafe and potentially illegal.
So what do you advise them?
Advise them to contact their previous doctor to arrange for a transfer of their medical records or care summary. Or, better still, register with a local GP practice urgently so a doctor there can access their full history, assess them properly, and establish an ongoing prescribing relationship if appropriate. You can't just issue controlled drugs based on the patient's word alone.
Okay. SAFER prescribing.
SAFER, prioritise safety. Have adequate knowledge of the patient. Be familiar with prescribing guidance, BNF local rules. Ensure treatment is evidence-based and needed. And report adverse drug reactions, ADRs, via the yellow card scheme. 19. Decision-making and consent. This is absolutely central to everything we do. Shared decision-making and obtaining valid consent are fundamental legal and ethical requirements for practically all patient care.
And the starting point for adults is assuming they have capacity.
Yes, you must presume capacity in adults unless there's evidence to suggest otherwise. Your role is to provide them with the necessary information clearly, without jargon about their condition, the treatment options, risks, benefits, alternatives, everything they need to make an informed decision that reflects their own values and preferences.
It's a dialogue, isn't it? Not just telling them what to do.
Exactly. It's an exchange. You need to listen to their views, support their decision-making process, maybe using interpreters if needed, or respecting requests to record the consultation. If a patient lacks capacity, then decisions must be made in their overall best interests, involving relevant people like family or those with power of attorney, and always considering the least restrictive option.
Okay, scenario. An adult patient comes in with suspected appendicitis. They're clearly confused, maybe delirious, unable to give consent for the urgent surgery they likely need. Their adult daughter is with them. What's the best approach?
Right. First step is a formal assessment of the patient's capacity specifically for this decision, consenting to surgery. Document that assessment. If they are found to lack capacity, then you need to act in their best interests.
Which involves the daughter.
Yes, you absolutely involve the daughter as a close relative in the discussion. You also involve the rest of the healthcare team. You discuss what's known about the patient's likely wishes and values, the clinical situation, and determine the overall benefit of the surgery, considering least restrictive options. Document this whole best interest decision-making process. If it's immediately life-threatening and delaying is dangerous, you can proceed under the doctrine of necessity while continuing the best interests process.
Got it. So INFORM for consent.
INFORM. Involve the patient, always. Provide necessary information clearly. Check they understand the facts. Respect the outcome, their decision. Record the process meticulously. And be familiar with the Mental Capacity Act principles for those who lack capacity. 20. Making viewing visual and audio recordings of patients. This guidance covers the ethical and legal side of making recordings, photos, videos, audio of patients. Again, respecting privacy and dignity is paramount.
Is specific consent always needed for any recording?
Not necessarily for recordings that are an integral part of the investigation or treatment itself. Think things like x-rays, ultrasound scans, maybe recording heart sounds for direct clinical comparison later. For these, implied consent as part of agreeing to the overall investigation or care is usually sufficient.
Okay. But what if the recording isn't for their direct care? Say you want to use it for teaching, research, maybe even public media.
Then you absolutely do need separate explicit consent. The patient needs to understand exactly why you're recording, how it will be used, how their privacy will be protected, for example, anonymization, where it will be stored, and that they can withdraw consent later.
Right. So, scenario. You want to take a photo of a patient's really unusual, diagnostically interesting skin condition. You plan to use it for teaching at a hospital grand round. The patient seems quite happy to help out. What's the proper process?
Even though they seem happy, you must get their explicit informed consent, specifically for this purpose, teaching at grand round. Explain how you'll ensure anonymity blurring faces, removing identifying marks. Tell them how the image will be stored securely and eventually disposed of. Document this consent carefully. And make sure you actually do anonymize it properly before using it.
Makes sense. Mnemonic for recordings? CROPP?
Let's try CROPP. Get consent explicit for secondary use. Ensure it's recording-specific consent. Use only necessary recordings. Protect privacy and dignity always. And protect the recording through secure storage and handling, just like any other part of the medical record. 21. Consent to research. Consent for research has its own specific guidance, building on the general principles. Valid consent here absolutely must be informed, given voluntarily, and by someone with the capacity to make that decision.
And participants need to know they can back out.
Crucially, yes. They must be clearly informed of their right to withdraw from the research at any time, for any reason, and that withdrawing will not negatively affect their ongoing clinical care in any way.
What about involving vulnerable people in research? Say, someone who lacks capacity.
There are very strict rules. For adults lacking capacity, research can usually only proceed if it's directly related to their specific incapacitating condition or its treatment. You need to follow detailed legal and ethical guidelines, which typically involve seeking the views of those close to the person, like family or someone with legal power of attorney, and absolutely critically, getting approval from a research ethics committee first.
Okay, scenario. You're involved in a research study and want to recruit a patient with a severe neurological condition. It's clear they lack the capacity to consent themselves. What's the essential first step?
Ensure the research meets the criteria. Is it directly related to their condition? Then you must ensure you have approval from a Research Ethics Committee, REC. You'll then need to follow the specific legal process for involving adults lacking capacity, which usually involves consulting with appropriate representatives about the patient's likely wishes and feelings.
So RAC approval is non-negotiable.
Absolutely non-negotiable for research involving patients, especially those lacking capacity. You also need to comply with laws around using human tissue, if that's relevant.
Okay. VALID consent for research.
VALID consent must be voluntary. Participants must be adequately informed. Special care for those lacking capacity or vulnerable, it must be an intelligent decision based on understanding. And document the entire process meticulously. 22. Treatment and care towards the end of life. This is obviously a profoundly important and sensitive area of practice. The guidance provides a framework for making decisions grounded in respecting human life, protecting patient dignity, and prioritizing patient-centered care. It heavily involves applying the Mental Capacity Act principles.
And encouraging conversations early is key, right? Advanced care planning.
Very much so. Doctors should support early discussions about preferences for future care, addressing patient wishes, fears, and values. This includes things like advanced decisions to refuse treatment, ADRTs, appointing a lasting power of attorney, LPA for health and welfare, and discussions about resuscitation status, DNA CPR.
What if a patient has capacity and makes a clear decision, say, to refuse all future life-prolonging treatments, including feeding tubes, but their family is really strongly against that decision? Whose view takes precedence?
If the patient has capacity and has been fully informed, their autonomous decision to refuse treatment must be respected, even if it leads to their death and even if the family disagrees. Your role then includes sensitively explaining this to the family, supporting them, but ultimately upholding the patient's legal and ethical right to decide.
That must be incredibly difficult sometimes.
It can be. Clear communication, empathy, and robust documentation of the patient's decision and the discussions are absolutely vital. Similar principles apply to decisions about clinically assisted nutrition and hydration, CANH, and do not attempt cardiopulmonary resuscitation, DNA CPR, orders. They must be based on clinical appropriateness and the patient's wishes or best interests if they lack capacity.
Okay, a mnemonic for end-of-life care, ADVANCE.
ADVANCE. Encourage advanced care planning. Uphold patient dignity. Understand patient values. Respect autonomy and capacity. If no capacity, act in best interests. Consult family team appropriately. Elicit end-of-life wishes. 23. When a patient seeks advice about assistance to die. Right, this is another very sensitive topic, and the legal position in the UK is critical background here. Assisting or encouraging suicide remains a criminal offense across the UK.
So what is a doctor's responsibility when a patient, perhaps suffering from a terminal illness, asks about assisted dying?
Your primary responsibilities are to continue providing compassionate and appropriate care, to listen empathetically to understand the reasons behind their request, the suffering, the fears, and to adhere strictly to the law.
So you can't give them information about, say, organizations abroad that facilitate assisted dying.
Absolutely not. Providing information or advice that could be seen as encouraging or assisting suicide is illegal. Your response must be limited to explaining the legal position in the UK and discussing the lawful clinical options available to them here.
Which would be focused on palliative care.
Exactly. The focus should be on ensuring all their palliative care needs are being met. Physical symptom control, psychological support, spiritual care, social support. Addressing their suffering through all available lawful means is key. You must not, under any circumstances, take any action that constitutes assisting suicide.
Okay, scenario. A patient with a rapidly progressing neurological condition, who definitely has capacity, tells you they're considering traveling abroad for assisted dying. They ask for your opinion on which country might be best. What's the safe and legal response?
You listen empathetically to understand their distress and reasons. Then you clearly and unequivocally explain that assisting or encouraging suicide is a criminal offense in the UK, and therefore you cannot provide any advice or information about accessing assisted dying abroad. Then you gently but firmly pivot the conversation back to what you can do, which is optimize their current care, enhance palliative support, address their fears and symptoms, and offer ongoing compassionate care within the bounds of UK law.
Got it. LAWFUL for the mnemonic.
LAWFUL. Discuss only lawful options. Assist no suicide. Focus on patient well-being. Focus on palliative care. Explain UK law clearly. Listen empathetically first. 24. Leadership and management for all doctors. This might surprise some trainees, but the GMC sees leadership and management skills as integral to being a good doctor right from the start of your career. It's not just for consultants or partners.
So it applies to everyone, even foundation doctors. What does it involve at that level?
It involves contributing positively to the team, improving patient safety and the quality of care wherever you can, promoting a respectful and inclusive working environment, working collaboratively, and even contributing to teaching and training junior colleagues or students, acting as a positive role model.
Okay, so say you're an F1 or F2 on a ward, and you notice staff morale is really low. People seem burnt out, maybe due to workload pressures, and you're genuinely concerned it's starting to affect patient care, perhaps leading to mistakes or delays. What's a good leadership step you could take?
A really good step would be to discreetly raise your observations and concerns with someone senior, your direct clinical supervisor, or perhaps the ward manager. Explain what you've seen, link it specifically to potential patient safety risks, and maybe even suggest some constructive ideas for improvement if you have any.
So not just complaining to your peers.
No, that rarely solves anything. Taking your concerns constructively up the appropriate channel shows leadership and responsibility. Ignoring the problem is also not an option if patient safety might be affected. It's also about managing resources fairly and managing your own interests to avoid conflicts.
TEAMS for the mnemonic.
TEAMS. Contribute to teaching and training. Help manage efficiency and resources fairly. Be accountable for your actions. Support morale and well-being. And focus on safety and quality improvement. 25. Raising and acting on concerns about patient safety. This follows on directly from leadership. All doctors have an absolute overarching duty to raise concerns if they believe patient safety, dignity, or comfort is being compromised. And importantly, to help create a culture where all staff feel safe and empowered to do the same.
So if you see something wrong, you have to speak up.
Yes, prompt action is required if safety is, or even may be, seriously compromised. If a patient isn't receiving basic care, you tell someone who can act immediately. If resources or policies are inadequate and causing risk, try to fix it if you can, but definitely raise it through official channels like your workplace's incident reporting system, for e.g. DATIX, or by speaking to a manager, and document the steps you took.
What about concerns about a colleague? Maybe you think they aren't fit to practice.
That's a tough one, but the duty remains. If you think a colleague's health, behavior, or performance is putting patients at risk, you should seek advice perhaps from another senior colleague, your defense body, or even the GMC's confidential helpline. If you're still concerned after seeking advice, you must report it formally, again documenting the steps you took.
Okay, scenario. You observe a locum doctor on your ward who seems to be consistently making medication errors, putting patients at direct risk. You've had a quiet word informally, but the errors are continuing. What's the definite best next step?
This has gone beyond an informal chat. Because there's a clear ongoing risk to patient safety, you must immediately escalate this formally. Raise your specific concerns about the locum's fitness to practice to your direct clinical supervisor, the consultant in charge, or the hospital's responsible officer. Follow your workplace policy for raising concerns about colleagues and document the specific errors and the steps you've already taken. Patient safety cannot be compromised further.
Right, no more waiting.
No. Delaying is a major pitfall.
SPEAKUP for the mnemonic.
SPEAKUP. Put safety first. Take prompt action. Escalate appropriately. Use all internal channels first. Keep records of everything. Understand your workplace policy. Going public is an absolute last resort and needs careful handling regarding confidentiality. 26. Duty of candor. Openness and honesty. Candor. This is the professional duty, and in England, also a statutory duty for organizations to be open and honest with patients and also with your colleagues in organization when something goes wrong in their care that causes or could cause harm or distress.
So it's about owning up to mistakes.
Yes, but it's more than that. It's about apologizing sincerely and importantly. An apology doesn't mean admitting legal liability. It's about taking professional responsibility. It's about explaining clearly what happened and what the likely short and long-term effects are, offering remedy or support, and crucially, reporting the incident internally so that lessons can be learned to improve safety for future patients.
Does it apply even if no harm actually occurred, like a near miss?
Yes, the professional duty of candor also applies to near misses that could have caused harm. Being open about these is vital for building a strong safety culture. You should also discuss potential risks with patients before treatment starts, as part of the consent process.
Okay, scenario. During a routine procedure, you make a small error, an inadvertent complication. It doesn't cause any lasting harm, but it does mean the patient needs to stay in hospital an extra day. What's the approach according to the duty of candor?
You must be open and honest with the patient. As soon as possible, explain fully what happened, why it happened, if known, what the immediate effects are, the extra day in hospital, and what you're doing about it. Offer a sincere apology for what happened, document the incident itself, your discussion with the patient, including the apology, and report it internally via DEDICS or your local system so that the team can learn from it.
So hiding it or downplaying it is completely wrong.
Absolutely. That destroys trust and goes against the core principles.
APOLOGY for the mnemonic.
APOLOGY. Apologize sincerely. Act promptly. Be open and honest. Foster a learning culture. Offer remedy or support. Give a clear explanation. And say, yes, things can go wrong. Let's learn from it. 27. Delegation and referral. It's really important to understand the difference here. Delegation is asking a colleague, often more junior but not always, to provide care or treatment on your behalf. You, the delegating doctor, usually retain overall responsibility for the patient's care.
Okay, so you're still in charge overall.
Generally, yes. And because of that, you must be satisfied that the person you're delegating to has the appropriate qualifications, skills, and experience to do the task safely and competently.
And referral?
Referral is different. That's when you arrange for another practitioner, often a specialist, to provide assessment or care because it falls outside your own area of competence. You're transferring responsibility for that aspect of care.
Right. In both cases, communication is key.
Absolutely vital. You need to inform the patient about the delegation or referral and why it's happening. You must transfer all relevant information about the patient's condition, history, and required treatment to ensure safe continuity of care. And you need clarity on who holds responsibility, especially if it's a temporary handover versus a permanent transfer. Ensure the patient understands and consents to their information being shared.
Okay, tricky scenario for junior doctor. You're on a busy ward round. Your consultant asks you to perform a procedure, let's say a lumbar puncture, that you've only watched once before, and you really don't feel competent or confident doing it independently. What's the safest and most professional response?
The safest thing is to be honest and assertive, but polite. You need to clearly state to your consultant something like, "Consultant, I've only observed that procedure once, and I don't feel competent to perform it independently yet. Could I please have direct supervision, or would you be able to do it?"
So don't just try and wing it.
Absolutely not. That risks patient harm and goes against the fundamental principle of working within your competence. Refusing outright without explanation might seem unhelpful, and asking someone even less experienced is irresponsible. Speaking up clearly about your competence level is the right thing to do.
Okay. SAFETRA and SFER for the mnemonic.
Let's break it down. Ensure colleague has skills. Acknowledge your responsibility in delegation. Share facts info clearly. Explain to the patient. Transfer relevant info, referral if outside competence. Get assurance if referring to non-registered therapist. Notify patient of transfer. Prioritize safety. Check familiarity competence. Ensure patient understanding. Record the handover. Yeah, covers the main points. 28. Acting as a witness in legal proceedings. Sometimes doctors get called upon to act as witnesses in legal cases, perhaps related to a patient they've treated or maybe as an expert in their field. The key principle here is that your overriding duty is to the court.
Not to the person who asked you or is paying you.
Correct. Your duty to the court comes first. This means you must act independently, honestly, and impartially at all times. Your evidence, whether written in a report or given orally, must be accurate, complete, and fair. Use clear language that the court can understand.
What's the difference between being a witness of fact and an expert witness?
A witness of fact testifies about things they personally saw or did based on their clinical observations and actions, relying heavily on the contemporaneous clinical records. An expert witness is there to assist the court with their specialist knowledge, providing objective, unbiased opinions within their area of expertise, and acknowledging if there's a range of professional opinions on a matter.
Crucially, you have to stick to what you know.
Absolutely. You must make clear the limits of your competence and knowledge. Don't stray outside your expertise. Be honest and trustworthy. Never provide evidence that's false or misleading.
Okay, scenario. You're asked to provide a factual witness statement for a court case about a patient you treated 2 years ago. You pull up the notes, but they're, well, a bit patchy, incomplete in places. You can't quite remember all the details not written down. What's the best approach?
Honesty is the only policy. You provide a statement based strictly and only on the accurate and complete information that is available in your records. You must explicitly state where the notes are incomplete or where your memory failed you regarding details not recorded. Do not guess, speculate, or fill in gaps. That would be dishonest. If you're unsure, always seek advice from your medical defense organization before submitting anything.
Honest for the mnemonic.
Honest. Be honest. Be objective and impartial. Base evidence on notes and records. Limit evidence to your expertise. Share factual information accurately. Your duty is the truth to the court. 29. Reporting criminal regulatory proceedings. Right? This is a professional obligation outlined in good medical practice. Doctors have a duty to inform the GMC promptly if they become involved in certain criminal or regulatory proceedings anywhere in the world.
Promptly, meaning without delay. What sort of things need reporting?
Yes, without undue delay. You must tell the GMC if you've accepted a police caution, if you've been charged with or found guilty of a criminal offense, apart from minor things like fixed penalty notices for parking, if another professional body finds against your registration, or if you're criticized by an official inquiry.
So even a caution needs reporting. It's not just convictions.
Correct. Accepting a caution is a formal admission of committing an offense, so it must be reported. The GMC needs to be aware of anything that could potentially raise questions about your fitness to practice or damage public trust in the profession.
Okay, scenario. You were charged with a driving offense, something more serious than a simple speeding ticket, maybe dangerous driving.
Yeah.
It's still just a charge at this stage, not a conviction.
Hmm.
What's your immediate professional duty?
You must inform the GMC without delay that you have been charged with that criminal offense. Don't wait to see if you'll be convicted. You should also inform any organizations you work for, especially if it could impact your work, and definitely seek advice from your medical defense organization about the implications and the process.
So ignoring it or hoping it goes away is not the right approach.
Definitely not. Failing to report when required is a breach of good medical practice in itself and could lead to separate fitness to practice proceedings.
Okay. INFORM GMC.
INFORM GMC. Report immediately. Notify about findings charged cautions. Report findings against registration by other bodies. Any criminal offense, usually. Report regulatory issues. Maybe a caution counts. Yes, it does. Applies globally. Minimal exclusions like fixed penalties. Consult your defense body or GMC if unsure. 30. Writing references. Doctors are often asked to write references for colleagues, perhaps for job applications, appraisals, or other assessments. When you do this, the key principles are honesty, objectivity, and fairness.
So the reference needs to be a true and accurate reflection.
Yes. It must be accurate, complete, and fair, including all relevant information about the colleague's competence, performance, and conduct. You mustn't write anything false or misleading, either explicitly or by omitting important information.
What about negative points? If someone was generally good but had some issues?
If there were relevant performance or conduct issues, especially if they were formally addressed or documented, they should generally be included factually and objectively. You need to base your comments on evidence, not personal bias. Avoid personal details unless they are directly relevant and you have consent, or there's a public interest justification.
Okay, scenario. You're asked to write a reference for a former junior colleague. You liked them personally, they were friendly, but they had some significant documented performance issues during their time with you, which were formally discussed and managed. What's the correct approach when writing the reference?
You have to write an accurate, objective, and fair reference. That means you must include the relevant information about those performance issues and how they were addressed. You can and should also include their strengths, but omitting the documented problems would be misleading and potentially unfair to the prospective employer, possibly even risking patient safety down the line. Stick to the facts, exclude personal feelings.
And you should normally let the person see the reference you've written.
Yes, the guidance says you should normally provide a copy of the reference to the candidate if they ask for it.
FAR for the mnemonic.
FAIR. Keep it factual. Make it accurate. Be inclusive of all relevant information, positive and negative. Ensure it's reliable and evidence-based. 31. Cosmetic interventions. Doctors who offer... cosmetic interventions. While specific detailed guidance wasn't in our core prep summaries today, the general principles of good medical practice absolutely apply to doctors offering cosmetic procedures, both surgical and non-surgical.
So things like honesty in advertising, managing conflicts of interest, and ensuring proper consent are key.
Exactly. You must make sure any information you publish about your services is factual, verifiable, and doesn't exploit patients' vulnerability or lack of medical knowledge. Aggressive marketing tactics or misleading before and after pictures would fall foul of this.
And patient safety is paramount, presumably.
Always. Your decisions about recommending or providing treatments must be based on clinical appropriateness and patient benefit, not driven by financial incentives or patient pressure. If you have interests in particular products or devices, these must be declared. Consent needs to be fully informed, covering risks, benefits, alternatives, and costs with adequate time for reflection.
What if a patient really wants a cosmetic procedure, but you genuinely believe it's not clinically appropriate for them? Maybe the risks outweigh the benefits in their specific case.
You must explain your reasoning clearly and sensitively to the patient, outlining why you believe it's not appropriate for them. And you should refuse to provide the treatment if you assess it as not being clinically indicated or of overall benefit. You are not obliged to provide treatments you deem inappropriate, even if the patient insists.
So it comes back to those core GMC principles again.
It does. Patient safety, informed consent, honesty, managing conflicts of interest, they all apply strongly in the cosmetic sector. 32. Good practice in research. We touched on consent for research earlier, but the GMC also has broader principles about good practice in research itself. The absolute foundation is acting with honesty and integrity in every aspect, designing, organizing, conducting, and reporting research.
And following established guidelines.
Yes, you must follow national research governance guidelines and, of course, relevant GMC guidance, like the consent principles we already discussed. Informed, voluntary consent, the right to withdraw, special protections for vulnerable groups, and the need for ethical approval.
Okay, scenario. You've been invited to be a co-investigator on a new research project. You're reviewing the protocol and documents, and you notice the patient information leaflet is incredibly dense, full of technical jargon, really hard to understand. What's the ethically correct step?
You have a responsibility to raise that concern. Speak to the lead investigator and potentially flag it to the Research Ethics Committee. You need to advocate for the information sheet to be revised into clear, simple language that potential participants can realistically understand. Informed consent isn't truly informed if the information isn't comprehensible.
So just hoping patients will ask questions isn't good enough.
No, the information provided must be accessible from the start. Proceeding with a complex leaflet compromises the validity of the consent.
Okay. ETHICS and research.
Let's try. Ethical approval is essential. Be transparent in methods and reporting. Act with honesty and integrity. Ensure informed consent is valid. Consider capacity and vulnerability. Prioritize participant safety. Yes, that works. 33. If sources include 2024-25 updates for PASSAs, note scope, and cross-references. And finally, just a really important point about recent changes. The GMC guidance, including the cornerstone document Good Medical Practice, has been updated effective from 2024 or 2025 for different pieces to explicitly include physician associates, PAs, and anesthesia associates, as the GMC now regulates these professions too.
Right, I've seen that mentioned. So does this mean that all these professional standards, everything we just spent this time discussing, now apply equally to PAs and DAs working in the UK?
Essentially, yes. The GMC refers to doctors, PAs, and DAs as three distinct professions working together. The professional standards set out in GMC guidance apply to all registrants, doctors, PAs, and DAs to the extent that they are relevant to their specific scope of practice.
So principles like confidentiality, consent, duty of candor, raising concerns, maintaining boundaries, they apply across the board.
Exactly. It's about ensuring consistent standards of professionalism and patient safety across the entire GMC-regulated workforce. So if you're working alongside PAs or ABAs, you should expect them to adhere to the same high ethical standards outlined in this guidance.
Okay, quick scenario then. You observe a physician associate, a PA working in your department. You see them giving what looks like medical advice on a public social media forum. They identify themselves vaguely as a healthcare professional, but don't specify they are a PA. What's the best approach?
The best first step would be a quiet, professional conversation. Approach the PA privately, remind them that the GMC social media guidance now applies to them too, and explain the importance of transparency using their real name and clearly stating their professional role, i.e. physician associate, if they're identifying themselves in a professional capacity online. This helps maintain public trust and avoids confusion.
So not ignoring it, but addressing it constructively.
Precisely. It's about supporting colleagues in upholding professional standards.
Okay, APPOY for the mnemonic.
APPOY. All GMC standards apply. Includes PAs and AAs. They are distinct professions. Must ensure legal compliance, yes, relevant to their scope of practice. Outro.
Wow, what a journey. That was a truly comprehensive and pretty fast-paced deep dive into that core GMC guidance. It really does form the bedrock of ethical practice, and honestly, it's absolutely vital stuff for your MSRA SJT. Let's try and pull out some real golden rules to keep right at the front of your mind.
Okay, golden rules, definitely. Safety first, always. Always prioritize patient safety and protection above all else. Number 2, escalate early if you spot a risk. If you're out of your depth, act promptly. Tell someone senior who can actually make a difference. Don't sit on concerns.
Right, and be candid, be open, be honest when things inevitably go wrong sometimes. Explain what happened, apologize sincerely. It's crucial for trust.
Absolutely. And protect data. Patient information is sacred. It's confidential. Only share what is necessary, get consent when you need it, or make sure you have a clear legal justification if you don't have consent.
Okay, what else? Respect consent and capacity. You've got to involve patients in decisions about their own bodies and care, respect their autonomy, and properly assess their capacity to make those decisions using the Mental Capacity Act framework if needed.
Couldn't agree more. And then document meticulously. We've said it a few times, but honestly, if it's not clearly, accurately, and timely written down in the notes, it's like it didn't happen. For accountability, for continuity, for everything.
So true. And maybe finally, know your limits and work as a team. Don't try to be a hero and work beyond your competence. Delegate safely, refer appropriately, and collaborate effectively with everyone in the multidisciplinary team, including your PA and AA colleagues now too.
That's a great summary. You know, navigating these complex ethical situations isn't just about ticking boxes for an exam. It's genuinely about building the foundations for a trustworthy, justifiable, and fulfilling medical career. Think about it. How can you proactively apply these guidelines every single day, even in small ways, to maybe prevent some of those really challenging situations from even arising in the first place? How will you embed these golden rules into your daily practice right now?
That's a brilliant thought to end on. Okay, that really is it for this deep dive. Remember, for a free SJT textbook and loads more podcasts to help you ace your exams, you can head over to https://www.passthemsra.com.
And don't forget to subscribe to us on YouTube as well. Search for Pass Them SRA. That's PASSTHEMSRA. The very best of luck with all your revision.